8 days before the Supreme Court declared that Uhuru Kenyatta and William Ruto had been validly elected, ICC Prosecutor Fatou Bensouda, in a written submission to the trial chamber, requested that Kenyatta's request to appear during trial via video link be rejected because it lacks legal basis. Bensouda argues that the Rome Statute is clear that an accused be physically present at trial. Article 62 defines the place of trial to be the seat of the court, unless otherwise decided. In her opinion, Uhuru Kenyatta has not in fact given any convincing reason to be granted the request. She describes Kenyatta's argument that he resides in a country external to the seat of the court as an unremarkable fact shared by every accused at the court. To Bensouda, that is not a basis to grant the extraordinary relief sought, and if it were, the court, she says, would quickly turn into a virtual tribunal where accused appear for trial only if it is convenient for them to do so. Another reason why Bensouda is opposed to a video link appearance is that technological problems are likely to interrupt and delay the proceedings, even to the extent that the integrity of the proceedings could be questioned. But even more important for her is that the Rome Statute provides that an accused can observe trial via video link from outside the courtroom only if the accused being present before court disrupts trial, which she says is not at issue here. The trial chamber has directed that all parties put in all their submissions regarding this matter by the 9th of April. But even as the matter awaits determination, the question whether the Kenyan Constitution protects a sitting president from such legal proceedings continue to ring in the minds of many. The Kenyan Constitution in Article 143, Section 1 states that criminal proceedings shall not be constituted or continued in any court against the president or a person performing the functions of that office during their tenure of office. No civil proceedings shall be instituted either during their tenure in office for anything done or not done in the exercise of their powers. But in Section 4 of Article 143, the Constitution gives an exception to the immunity that the President can enjoy. It states that the immunity of the President shall not extend to a crime for which the President may be prosecuted under any treaty to which Kenya is party and which prohibits such immunity. Uhuru Kenyatta and William Ruto, who will officially become President and Deputy President of the Republic of Kenya Tuesday next week, are facing charges against humanity at the International Criminal Court, which was set up under the Rome Statute. Now, Kenya is party to the Rome Statute, and it prohibits immunity to any indictee. International criminal law experts say this essentially means that Uhuru Kenyatta and William Ruto, in their capacity as President and Deputy President of Kenya, have no immunity regarding their impending prosecution by the ICC. The international community, particularly the United States and the European Union, will be keenly watching them and their government in the coming months. In an email to the Nation Media Group, the United States Department spokesperson for African Affairs, Hilary Renner, says, quote, "We cannot ignore the serious challenges that have been set out in the ICC indictment and will calibrate our engagement accordingly." However, Renner added that the U.S. does not expect to curtail its cooperation with the government and the people of Kenya on mutual priorities. What is of interest to the U.S., she says, is that Kenya lives up to its commitment to ensure justice prevails for all. Sylvia Chebet, Citizen Live at 9.